Good morning.
Good morning.
First, I'd like to offer my condolences and deepest sympathy to the Browder family, who are privately mourning their loss of their beloved son and brother. Kalief Browder's story is tragic. He was arrested at 16, incarcerated in Rikers, sustained brutal violence at the hands of prison guards and fellow inmates while being held 1,000 days without due process for allegedly stealing a backpack. Kalief Browder's story is tragic, but not uncommon. He was unable to make bail, and the Bronx District Attorney office repeatedly failed and delayed his trial. Kalief Browder's story is tragic, but not unique. His family had no money to bail him out. 3 birthdays later, the charges were dismissed. After his release, he struggled to adjust back into society. He was in prison without bars. Sadly, he took his own life. Kalief Browder's story is tragic and reflects the experience of so many who become broken by a broken system. Kalief Browder's story is tragic. This is one of the reasons why I've introduced in the City Council Resolution 430, calling on New York State legislators to pass and the governor sign to repeal Criminal Procedure Law Article 240 and replace it with a law mandating early, open, and automatic pretrial discovery. It will help innocent or overcharged defendants prepare for trial. It will encourage guilty defendants to plead guilty without needless and costly delays. Under New York antiquated criminal discovery statute, defendants are denied vital important information essential to make rational decisions about their pending cases. The limited information they receive is also turned over so late in the process that it's impossible to intelligently investigate, to secure or use any potential exculpatory evidence to fairly weigh a guilty plea, offer, or develop a trial strategy. When you're accused of a crime and are arrested, you have 2 options. Either you choose to admit to the crime, even if you didn't do it, because you may be pressured into a plea bargain, cop out by the prosecution, or choose to go to trial. Criminal Procedure Law 240 allows prosecutions to settle cases quickly with minimal resources by offering plea bargains, even though the accused do not know the evidence against them. Both options carry risk of going to jail and having a criminal record for life. Kalief Browder stood his ground, pleaded innocent, and it cost him time and ultimately his life. It's a tragic story, but we need to put these tragic stories to rest. I will add to all of this, I've had conversations with DAs, the Bronx District Attorney's office here, spoke with Kenneth Thompson, and while there are some district attorneys around the state who have open discovery and who do an excellent job in making sure that at first glance that the defense has a fair, adequate chance of defending their client, all across the state, that is not the case. If that was the case, we'd not be standing out here today. If that was the case, we wouldn't be trying to change the system. If that was the case, we wouldn't have a Kalief Brown, we wouldn't have people sitting in Rikers for 3 and 4 years waiting to get out of jail, waiting to get a fair chance. If that was the case, we wouldn't have people killing themselves. If that was the case, we wouldn't have brutality. If that was the case, we would have fairness in the justice system. So I ask my colleagues in government, if you haven't signed on, sign on. I ask my colleagues in the state, let's do the right thing by the people of New York. It doesn't make a difference what color you are. Fair is fair. And if we're talking about a criminal justice system, I said maybe we should make it a civilian justice system so all our civilians will have proper rights and the proper justice that takes care of them. Because once you label somebody criminal, you already have the perception in your mind that they've done something wrong. But if we're standing out here for the people who have been locked up for the things they haven't been accused, but haven't been found guilty, or let alone having the chance to prove their innocence early on. Let's save a life, let's save some money, and let's save New York together. Let's repeal 240 and put in a law that makes sense. Thank you.
I stand before you as a retired New York City detective. I joined the force back in 1984. I retired in 2004. What happened to Kalief Browder? People have said it was a tragedy. Well, let's correct that. It wasn't a tragedy. It was a travesty.
Right.
A tragedy is something like an act of God that can't be stopped. A travesty could be corrected. And all we're saying here is when a person is arrested, the evidence that the district attorney, because as a police officer, as a retired detective, we give all the evidence that we gather to the district attorney. We give that to the district attorney within 2 or 3 days. The district attorney withholds that evidence until the first witness, up until 1 hour, when the first witness takes the stand. Now that could be a person languishing in jail for 1.5 years, 2 years. In this county here, the Bronx is notorious out of all 5 boroughs. You get arrested in the Bronx, it's going to take you a minimum of 2 to 2.5 years for your case to come to trial. During that 2.5 years, the district attorney is withholding all of the evidence against the person that's accused. All we're saying with criminal procedure law 240, which gives the district attorney the right to do that, we're saying we want that now repealed, and we want to enact 245. What 245 says is that both sides get the evidence. We're interested in the truth. We want everybody to be equal. We don't want the district attorney to have more evidence than the defense. We don't want the defense to have more evidence than the district attorney. All we're asking for is equality. What happened here with Kalief Browder is that the district attorneys are more interested in convictions rather than the truth. We need the truth to follow convictions. We don't need convictions following the truth, because when we get convictions following the truth, that means that a person stayed in jail for something that they did not commit, for a crime they didn't commit. We want both sides to share evidence. It's happening right across the bridge in New Jersey. Other states, even Texas of all states, whose mantra was we try them and we fry them. Last year, under Governor Perry, they abolished 240 and enacted 245. If Texas can do it, why can't New York, which is supposed to be leading everybody, do it? Like it was said earlier with the Councilman Andy King and with my partner Julio Pabon, I may be a little bit off on these figures, but this is something you need to know. To house a person in jail in New York City costs $167,000 a year over. To do the same housing in California and other states is close to like $50,000. Why is it almost 3 times to house a prisoner in New York than these other states? It's because it's a business, folks.
Right.
It's a business.
Yes.
And too many times, our people, and this goes across color barrier lines, but why does our people, blacks and Latinos, always have to be the money behind this, generating this business? Why is it always us? Why do we have to be the collateral damage all the time? It has to stop, and it has to stop now. Every day you see somebody coming home from jail after doing 10, 20, and 30 years, only to find out that they did not commit the crime. I'm here telling you, they didn't find that out 25, 30 years. The district attorney knew from day one. But what they do is they try to plea bargain because they're more interested in convictions than the truth. And that needs to stop. I'm not saying that the district attorneys, all of them, are bad. I believe they're good-hearted people. and they're following a script for 50 years that needs to be abolished now. Let's seek the truth and not convictions. Thank you.
Today we're gathered here because once again, our system has failed us. We have a young man, we have a human being who was accused of a crime. He had the temerity to stand his ground. He had the temerity to say that I want my due process. By circumstance, by economics, by the virtue of the system, or the in virtue of the system, this young man went through a psychological highway that he did not travel. He went 3 years, on the most crucial years of a young person's life. And then, tragically, he had taken his own life. When we have a system predicated on devouring our young, there is no justice. Ruth Hassel Thompson, Senator, who's the ranking member of the Crime Victims Crime Corrections Committee, has been working with her colleagues. We are asking the state legislature, the assembly has passed it, we need the Republicans to get on board with this. We need the New York State Prosecutors Association to stop passing block on this legislation. We have a complete crime reform package. We want to raise the age so these things won't happen. We want to make sure that 240 dies. Today is the last day of the legislative session. This is not going to die. This movement is not going anywhere.
A lot of you must be thinking, well, this happened to this particular individual. This is a case that doesn't affect us directly. I live up the block. I had an apartment up there. My son graduated from Wesleyan University. Never been involved in any issues whatsoever. Leaves my house to go down the block to buy a sandwich. He gets arrested by police in a roundup over there. I go to the police department because we didn't hear from him for 24 hours. When we finally get there, they said my son was arrested for possession of narcotics and intent to sell. That almost blew my mind, because if you know your children, you know what they're capable of. The police told us, I spoke to the police officers who made the arrest, and I said, are you sure you have the right kid? Because I know my son. And he told me, oh, we got plenty of evidence, and we know how you parents are. We understand, you probably think this never happened, but you'd be surprised what kids are capable of doing. The bottom line is refused to plead guilty. The judge wanted him to plead guilty. Supposedly just a desk appearance ticket. We say that's nothing. But we said he's not going to plead guilty for something he didn't do. Bottom line, it took almost 2 years. How much money that cost the court for them to come back after 2 years and say to me and my son that they had no evidence. No evidence whatsoever. If I would have been another parent with less resources, my son would have been in jail for possibly 2 years waiting for something that never happened. That happens a lot. These courts, if you go there, you see the lines outside. This has become a business, folks. It's a business.